In the United States, CPS makes upwards of $3 billion per day on trafficking and selling our children. The corruption may start with the caseworker, but goes through the judicial system, passing the governor through the Senate and into the White House. The entire system has a hand in the business known as CPS.
Our children are stolen every minute of a 24-hour day. They are being robbed of their innocence, their trust, their happiness. As parents, we are isolated and betrayed by lives. Only 12% of the kids taken will be reunified. Title IV funding is being riveted with fraud.
All right, there's something to be said for the world of production, folks. Thank you for joining us. This is CPS Punisher on a Wednesday evening. Yeah, I mean, if there's any people out there that are producers that want to work with us on this show, so that I don't have to do all these and I can't be blamed for all these flaws, that would be really cool. You can email me at abolishcps.com at gmail.com and say you'll take the spot right away. That'd be greatly welcome. Also, if you guys are watching this, wherever you're watching, whether it's Facebook, YouTube, any of that stuff, like, share, subscribe, ring the bell, all of those things, please, because that helps us get our word out more and more and more and more people. The more you guys like things, the more you subscribe. That helps us reach more people so we can get more subscriptions, so that we can start getting some funding, so that helps us pay for these productions that we do. It's very important for little groups like us to have a strong showing of support. And if you're able to or whatever, please, there's a support tag on the show. Throw a few dollars our way to help support the stream. It's none of this stuff is free that we do, and it would be greatly appreciated. That all being said, so this week we've kind of been going over bits and pieces of what it takes in a CPS investigation, as far as we've heard about different laws and angles of going at the CPS case. And you're going to hear a lot of this stuff from a lot of people. So if you didn't catch it all, don't worry about it. Either someone else is going to rattle the same stuff off to you, or we're going to rattle it off again. So don't worry about if you miss things. And you know what? You can always go back and replay the episodes if there is information. I mean, that guy, Chris, yesterday, he had a ton of information that he was back through. And you should really just watch that video 3 or 4 times just to wrap your heads around what was said. So tonight we were all just talking. And what about the law side? What does it take to become a lawyer? What is the grind and the grind that you have to go through to become a lawyer to fight CPS? And is that even what you were intending to do when you were in college? So because we have an amazing constitutional lawman that's not washed up, he is just disbarred, so he can't get out in this fight because they didn't like him, and his ideas are obviously they're doing things, because they don't disbar people because they're bad lawyers. They disbar them because they're coming up with the truth, and they're making waves. And the only way that they can stop them from doing that is by disbarring them. So, that being said, I'm glad, Charles, that we have you here, because you are someone that is making these waves, my man. And I'll bring everybody else out as well. We got Brenda with us tonight. We got Herbert, and we have Melissa here somewhere. How we doing, guys?
Okay.
Hello.
Brenda, how you doing? All right. Charles, let's talk about this. How we doing, my man? Let's talk about, what does it take to become a lawyer in this world?
Well, okay. I mean, what it takes to become a lawyer, what it takes to become and stay a force for change. Those are two very different questions. Lawyers are basically forces for the status quo and forces for the establishment and forces for maintaining the institutions that exist as they are. I mean, last night we heard from Chris out in California talking about his personal perspective. It's very close to my perspective, I'll say, but after the show, I had a little conversation with Chris, and I said, "You got to lay low, or they're going to take you back." Well, there's this saying, "Physician, heal thyself," and today I got a reminder that I am still on the radar and still making waves and still threatening the system to its core. And up to a point, it makes me feel like, okay, I still have a reason to be alive. But when it came in the mail this afternoon as a new federal lawsuit against me, I was a little bit surprised, and I'm now just thinking about what it all means. But what does it take to become a lawyer? I'll address a few minutes of time to that. I mean, it basically requires going to college, then going to law school, or in some states now, an increasing number of states, practicing law in a law office, and then taking the bar exam. There in Oregon and a couple of other states, they're eliminating the bar exam, which is kind of a shame because the bar exam is, at least for me, it was other than my judicial clerkship, it was the first real practical knowledge of law I ever got, and especially in Texas, it was a very practical, practice-oriented bar exam, and I think it's a shame. I think that basically, ideally, the only requirement to practice law should be the bar exam. One like Texas that includes the Texas Third Day, which was all about rules of civil and criminal procedure, which you don't really get a practical understanding of in law school at all. I got some by working for judges, but basically, up to a point. I mean, this is going to be a strange thing. I mean, Christians all know that we are when we die, we are reborn, and in our baptism, we are reborn. And so, being a Christian is all about death and rebirth. And up to a point, I think that what does it take to be a really good lawyer? You need to be disbarred. You need to die to the system and then be reborn as a crusader. I was already a little bit of a crusader as a lawyer, but I would say that my life in the law, my real education in the reality of the law, began the day I was disbarred, and everything before was just an law school. Law is not the real world. The practice of law is not the real world because you're insulated from all the harm. You're in there promoting the harm. And once you're disbarred, you are suddenly a victim. You are one of the people. You really become one of the oppressed. And it's only from the standpoint of the victims of law, the victims of oppression, that law is really meaningful. And so every lawyer who's merely a part of the elite is an ignoramus. Last night, in response to Chris's comment, I circulated. Herbert, I don't have your email. I asked Darren for it, but maybe you can send it.
Yeah, we'll talk about that after too, Charles, because I know that you had said you sent me some emails and I don't have them.
Don't worry about it. Don't worry about it. I was just saying I wanted to send Herbert my comment on law as the bar as nobility. Okay, thank you.
Got it. Hey, I just gave it to you. You see it?
Yes, I see it. I do see it, and so thank you.
Okay. I'll give you my phone number too.
I did. Don't announce that publicly.
Why not?
But anyhow,
Who's going to come after me?
anyhow, if you want to do, but anyhow, my point is that the law is and always has been a support for the establishment, and it is a support for the prison system. It is a support for the banks. It is a support for mortgage foreclosure and eviction. It is a support. My apologies to Herbert. It's a support for the police. Every instrument of oppression depends on the law, and it depends on the law as Play-Doh in the hands of lawyers and judges, but not in the hands of the people. The people are told that it's basically radioactive, it's toxic, they cannot manipulate it. And basically, this is now what I'm told in this new federal law that was just filed against me. There's 7 counts against me, all coming down to they want a nationwide injunction against against me engaging in the practice of law, because I help with things like forum shopping. Oh, doesn't that sound evil? Getting away. Forum shopping means getting away from judges who are screwing you over. That's one of the things I was doing. Using the law to the advantage of the individual against the system. That is what I'm accused of doing, and it's kind of interesting. And I want to talk about the thoughts I've had. It's only like 6 hours since I found this out, so these are only my first 6 hours of thinking about it. But the answer, part of the answer, I think that some of you may be familiar with the New York Second Amendment case, from a year or two ago. The Supreme Court decided a case out of New York and basically said that no state law restricting the ownership and possession of guns would be constitutional unless it was found to be part of the tradition of the United States and its culture. It's basically its law and its culture. And I think that up to a point, I want to raise exactly the same argument in the First Amendment context, that the First Amendment, everything that lawyers do is basically protected by the First Amendment. They associate with people, they talk to people, they publish, they write, they petition for redress of grievances. The First Amendment is all about the practice of law in much more detail, even than the Second Amendment is about the protection of liberty. The First Amendment definitely is. And I think that basically I want to raise that argument as the core of my response to this complaint. And then the other thing I want to do is talk about antitrust laws and monopoly. The bar is a commercial monopoly. This is Jerry O'Neill's. I've mentioned Jerry O'Neill in Montana several times on this show. The bar is a state-operated monopoly. And there is a doctrine of state-operated monopoly called the Parker Doctrine, dating back from the 1940s. Guess what? The first 10 years of Franklin D. Roosevelt New Deal out of the state of California, and basically the fruit industry, particularly the apricot growers of California, were in big trouble, and they needed basically to socialize the apricot growing industry and share the risk and the cost of production of apricots and other fruits. And the state of California created basically an agricultural industry that was controlled by the state. And some people challenged that and said this is a clear violation of the antitrust laws. And the state and the Supreme Court of the United States, in the Parker decision, said no. We are going to allow the state of California to create a state-run monopoly. But what I want to do now with the bar is saying, can the states, remember the California bar was only created in 1927, 16 years before this decision in Parker. Is the bar, is it just like the apricot business? Is it of no more constitutional importance than the apricot business? Or is the California bar actually an organized monopoly against freedom of speech? And can, under the Parker Doctrine, the Parker Doctrine itself is an exception to the antitrust laws. And do we need now to carve out, based on the principles outlined in the Second Amendment case 2 years ago, the Bruin case, do we need to now carve out an exception to the Parker Doctrine that states cannot create a monopoly on constitutional rights? And basically, that is what the state, that is one way of framing what a state bar is. A state bar is a monopoly on thinking and speaking about the law. And, you know, that's why Brenda's husband is in trouble. That's why, let's see. Let's see, Herbert just sent me, am I aware of the decision to address requests for civilians to be carried firearms? I mean, they call, several states have enacted, including Louisiana, have enacted what's called constitutional carry. You know, that means that the state, that the Second Amendment applies and cannot be limited. The Louisiana, the people of Louisiana in, I guess, 2012 actually voted in a special amendment that said that any restriction on Second Amendment rights in Louisiana would be subject to strict scrutiny. Well, ironically, the Supreme Court has held for many years that any restriction on First Amendment rights is subject to strict scrutiny, meaning that the highest level of constitutional examination. We were talking a little bit about it in relating to gag orders the other day. I quoted one of my favorite cases, Nebraska Press Association v. Stewart from 1976, and it's a very exacting standard. And the whole issue is that the Constitution enumerates a few very important rights, and there's a reason why the First Amendment is first. It's because everything to do with law and politics is the creation of law, and law is how we live. And you can't have a private government-controlled monopoly. Think about that, a private government-controlled monopoly. What a contradiction in terms that is. But you cannot have a monopoly business that controls the ability to speak. But that is what the bar is, and that is what we need to fight. As Chris last night was saying, the bar is in effect a new modern elite, a new modern title of nobility, and structurally and functionally, that is true. The bar is the structural and functional equivalent of the ancient nobility. They may not be using the titles of dukes and earls, but as a matter of fact, and they only indirectly pass it down from father to son. Ironically enough, my great grandfather was a judge, and my son is a lawyer. But it doesn't mean that it's officially hereditary, but it's kind of unofficially hereditary, and so it has become a title of nobility, and we've got to address it from the Republican standpoint. And a Republican form of government will not tolerate a monopoly on the exercise of constitutional rights. That has to be our position, and that has to be our crusade and where we're going. And Darren, you were mentioning that people that your channel needs assistance, and obviously I encourage you, but I've got to warn you, I'm going to have to be doing some fundraising myself to fight this new lawsuit, because this has got to be either my version of Custer's Last Stand, Battle of Little Bighorn, or more optimistically, maybe it'll be my Battle of Yorktown.
Do you have anything set up? Do you do a fundly yet, or any of that stuff, Charles?
No, I mean, I have this organization called the American Legal Defense Fund, and I can accept contributions through that. But I haven't done any advertising, but I've definitely got to start because this has to be the fight of my life, and I am going to relate it to Jerry O'Neill's campaign in Montana that I've mentioned so many times. I'm thinking that I'll ask for an extension of time to file my original answer in the case until after June 4th, which is the date of the election in Montana, to see if Jerry is on the ballot. And I don't know, it's a challenge. It's in one sense, it's depressing. It's never pleasant to be handed papers saying that you're being sued. But golly, after 24 years, they still see me as a threat of nationwide proportions. And okay, I accept the challenge. I'll go ahead and deal with it. Brenda, what are you laughing?
It's like a chess game, in other words. No, I was thinking, did anybody talk about the fact that the Supreme Court is passing whatever they do to pass it into law, but to ban mass protests in Louisiana, Mississippi, and Texas? Did anybody hear about this?
I have not heard anything about it. I saw your message earlier today, but I haven't had a chance, given everything else I'm looking at, I haven't had a chance to think about it. What do you know? I mean,
I kind of saw somebody did like a TikTok clip on it, and then I looked it up, and it is factual that the Supreme Court had passed this law. Like, so you can't assemble like in a mass group to protest anything if you are in these states. I guess you're gonna have to do it on your own.
Okay, let's see. The Supreme Court abolishes the right to mass protest.
Did they give a number of how many people is considered a mass?
I don't know, but let's just see what it says. The Supreme Court announced on Monday it will not hear, so it just they denied cert. Atkinson v. Doe. Decision not to hear Atkinson leaves in place a lower court decision that effectively eliminated the right to organize a mass protest in the Fifth Circuit, which is states of Louisiana, Mississippi, and Texas. So they didn't actually do anything affirmative. They just refused to hear.
Oh, I see. Okay.
It was denial of certiorari, and apparently this was a black group. This, under the lower court decision, a protest organizer faces potential ruinous financial consequences if a single attendee at a mass protest commits an illegal act. Okay, this is very much like Charlottesville, isn't it? Charlottesville in Virginia 7 years ago, one this deeply disturbed fellow ran backwards into a protest and killed her, and that was a terrible thing, of course. But they used it as collective responsibility for everybody involved. It is possible that this outcome will be temporary. The court did not embrace the United States Court of Appeals to the Fifth Circuit's decision attacking the First Amendment right to protest. It did not reverse it either. That means that, at least for now, the Fifth Circuit's decision is the law in much of the South. And for the past several years, the Fifth Circuit has engaged in a crusade against DeRay Mackison, a prominent figure within the Black Lives Matter movement, who organized a protest here at Baton Rouge, Louisiana Police Station in 2016. The facts of the Mackison case are unfortunately quite tragic. Mackison helped organize the Baton Rouge protest following the fatal shooting of Alton Sterling. During that protest, an unknown individual threw a rock or similar object at a police officer. The plaintiff in the Mackison case was identified only as Officer John Doe. Sadly, the officer was struck in the face and, according to one court, suffered injuries to his teeth, jaw, brain, and head. Everybody agrees that this rock was not thrown by Mackison. However, the United States Supreme Court in NAACP v. Claiborne Hardware held that protest leaders cannot be held liable for the actions of a single protest participant, absent unusual circumstances that are not present in the Mackison case, such as if Mackison had authorized, directed, or ratified the decision to throw the rock. Indeed, as Justice Sonia Sotomayor points out in a brief opinion accompanying the decisions not to hear Mackison, the court recently affirmed the strong First Amendment protections enjoyed by people like Mackison in Counterman v. Colorado. That decision held that the First Amendment precludes punishment for inciting violent action unless the speaker's words were intended, not merely likely, to produce imminent disorder. So, okay, I follow what's happening. I know the case of Claiborne Hardware very well. The reason Claiborne protests protects protest organizers should be obvious. No one who organizes a mass event attended by thousands of people can possibly control the actions of all those attendees, regardless of whether the event is a political event, a music concert, or the Super Bowl. So think about that. How many people go drunk driving?
It's just another anti-insurrection law since we're coming up to the election.
Yeah, well, I mean, I would call it another law favoring arbitrary and capricious enforcement of the law, because as Fifth Circuit Judge Don Willett, who dissented from this court's Mackison's decision, warned in one of his dissents, the court's decision would make protest organizers liable for the unlawful acts of counter-protesters and agitators. So, under the rule, the Fifth Circuit's rule, a KKK could sabotage the Black Lives Matter movement simply by showing up at its protests and throwing snow. Or Charlottesville on the other side.
Hey, Charles, I got an interesting one for you. It was actually something that I just seen a second ago on the news. I'm still not sure how this would be legal and doable, but it says, woman takes dead man into the bank to withdraw his loan.
corpse.
Where did this
Yeah.
happen? Where did this happen?
Oh no, it doesn't say where it happened. It was just on Channel 10 News. And you can see she has the body in a wheelchair. She grabs the corpse's hand and writes the name.
Right.
Well, I mean, that's kind of weird, but you know, she didn't have a power of
What's
attorney
Channel
or something?
10 News? Like ABC, NBC, CBS?
Fox.
Is it Fox?
Yeah.
Okay, Fox. I'll
Trust
look
me,
it up.
if you just ask Google, you can find it. I'm sure that one will pop up everywhere.
Well,
But I mean, how would the loan be valid if the person is no longer breathing?
Well, we gotta check it out.
that just sounds very weird.
Can somebody
not
Google?
sure.
Can somebody Google that?
Yeah, what exactly do we Google for that term?
What you just said?
Woman
Yeah.
takes dead man in to
Yeah,
withdraw
where was
loan.
it? Yeah, like woman, dead man hand or something. Let me see here. Let's see what we can come up with. Hopefully nothing gets sidetracked on this. Charles, when was it that you started looking at CPS as a way to go ahead and avenue down for your law studies or maybe your after law career?
Well, no, it was actually before I was disbarred. But much like Chris last night, my first contact with CPS was I voluntarily contacted them because of my wife's behavior during my own divorce almost 30 years ago, and what I saw at that time and then learned was a nationwide pattern. Was, I hate to say this, but they look at a situation, they look at who the most abusive or likely to be abusive party is, and they back that person and empower the abusive party, because basically that promotes the breakdown of the family, destroys legitimate education of children, and promotes dependency. So they always back the person who is most likely to lie, cheat, and steal. This is what CPS does. They are the opposite of child protection. They are, in effect, well, as you know, they are all about child enslavement. And so that was where I started. That was back in the 1990s. And I mean, I rapidly concluded that I mean, as I've said on this show before, that the family courts are basically the most, well, I mean, I don't know that they're more unconstitutional, anti-constitutional criminal law courts, but they're pretty damn close. The family courts and the criminal courts. And now I would add the mortgage foreclosure industry. All the courts, in essence, want to suppress people. And I mean, it's coordinated, it's consistent, it's constant. Coordinated, consistent, and constant harassment and subversion of individual rights and family autonomy, family integrity, and above all, the integrity of people who uphold traditional values. You know, it is so sad, and I see it everywhere. I sometimes think, oh, this is an exceptional circumstance, and then on closer examination, no, it's not. I mean, the people you have on this show, talking to Melissa and her friends, talking to everybody I talk to around the country. it is a consistent. I don't know whatever happened to Bill Trudell in Florida, but he was one of the first people I talked to who confirmed to me that all over Florida, CPS was doing exactly the same thing. CPS was basically favoring abusive parents over non-abusive parents. Why? Because that generated more business for the family lawyers, because the good parent will fight harder, and so the system needs to support the bad parent who causes the trouble.
Well, and more than that, the bad parent is going to get recurring, complaints. So it's job security. If you give the the abusive parent the child, when he gets abused again, they get to come out and investigate again. They get some more money off of it, and then they give the kid back, and it's a repeated process.
Right, over and over it
Bill
goes.
Trudell was in Tampa, Florida, Hillsborough County, Florida, and this is close to 20 years ago. He was trying to make a documentary, and in the middle of that documentary, he suddenly disappeared, and I lost track of it. And I hope he didn't disappear with prejudice, as they say. But it's amazing how people who try to show this system up for what it is often do disappear, either with prejudice or just because they find that they cannot live in the state of constant warfare that somebody like me gets used to. This latest lawsuit, I haven't had any trouble with any authorities of any kind in a very long time. What can I say? I've kicked up some more dust, and so we just, if we're going to fight the system, we better kick up dust, or else we aren't getting anywhere. But we have to fight, and we have to fight smart, and we have to fight with all due reflection, and using the law, using the contradictions in the law to undermine and reform the oppression.
You
look tired, Darren.
No, I'm good. I'm reading these questions after you. What do you think, Charles? What do you think your biggest hill to travel for getting your law license was?
The biggest what?
Your biggest feat. What was your biggest hill that you had to climb to get over when you were trying to become a lawyer?
Oh, becoming a lawyer was very easy for me. I mean, I had all but completed a PhD at Harvard when I started law school, and I think I've mentioned this. I've said it so many times, but if not, I'll repeat it here. That when I first got to law school, my thought was, this is not graduate school. This is like high school. This is it. And then I met Professor Duncan Kennedy at Harvard, and it turned out that Duncan Kennedy had written a book that started off with the premise that basically law school is exactly like high school. It has the in crowd and the out crowd, and it's all about teaching people conformity. Duncan Kennedy, his Little Red Book, that's the legal hierarchy in the reproductive system, it's called. And law school is not difficult. Law school is very easy. The bar exam is very easy. It's dealing with the judges and the power and confusion created by a political agenda that is secret, because you don't. They tell you in law school. They basically affirmatively mislead you. You cannot use politics as an explanation for inconsistent outcomes in law. You have to go through this artificial mental gymnastics of justifying contradictory contradictory outcomes, contradictory laws by legal reasoning, it's called. And you basically have to create fictional stories of how arbitrary and capricious decisions can be justified. And that's just, it is a monstrosity of lies, because law is all about the implementation of political choices. And that is why I think a fully informed jury system would be so much better than the system we've got. Because if responsible, educated people were operating juries, then you wouldn't have single judges implementing individual political agendas. The political agenda that a jury is going to implement would be the agenda of a society, hopefully society as a whole. I mean, the Federalist Papers that were written in 1787 to 1788 by James Madison, Alexander Hamilton, and John Jay are replete with warnings about cliques and minorities subverting the will of the majority. That is one of the most common themes that they saw in as a pitfall in democracy, that minorities, minority interests could, by spending money or whatever, take control of the system as a whole. And clearly, the bankers and the bankers and the lawyers have done that. They have completely subverted the judiciary and the legal system generally, and really the executive and legislative also, to implement one single agenda. And that is why the overall sweep of law is so consistent. One direction, headed ever more towards destruction of anything that is old and traditional in favor of basically what is communist. That has been the consistent pattern. And the reason is, of course, not that the elite, lawyers and bankers really want to share the wealth, but that by the promise of sharing the wealth and sharing power, by that promise to the people, they can get the people to support concentrating the power in them. It is a lie. It is all about a lie. It is all the lie that Child Protective Service is really protecting children, when it's really about enslaving children. The lie that the family court is about the best interests of children, when it really, if it's in the best interest of anybody, it's in the best interest of lawyers and judges.
Right.
Maximizing their power, maximizing their wealth. And so in terms of the most difficult things about being a lawyer and becoming a lawyer, it's realizing what's really going on, the political agenda that hides behind the rhetoric of legal reasoning. That is because, as an anthropologist trained in the social sciences, I immediately saw that every law was politically formed, politically shaped. And, you know, Duncan Kennedy, the critical legal people at Harvard absolutely agree with that. But there again, you find that they become part of this minority elite that is really twisting the legal system to their own benefit. We have to, the people in every jurisdiction have to take over again. That is the only hope. And the law needs to be simplified. It needs to be democratized. It needs to be demystified. And the only way to do that is to take it out of the hands of individual judges who are basically a nobility, a high priesthood, if you will, and putting it back in the hands of people to decide. Law will always be political. I'm not saying that there's a kingdom of heaven where law will always be just and fair, because people aren't just and fair. But it's a better chance that if ordinary people are making the decision for other ordinary people, that it will be fair and even and in the interests of the of most people. We will until Christ comes again. We will not have perfection on earth. But the people acting out of common sense for their own and other people's benefits, that's the best possible bet. And I mean, that is what we have totally lost in this country, in our obsession with experts and turning over every decision. I mean, in a family court case, you see that the lawyers themselves, they hide their own arbitrary and capricious acts under using people like CPS and certain experts, expert witnesses, as advocates for one position or another. So there's basically one level of experts on top of another. It all increases the cost, it increases the expense, it increases the confusion, and ultimately it just means that the ordinary people, the families, the parents and children of most of the people in the United States are totally lost. And so we've got to, but it all comes down to this monopoly. And it is an anti-democratic, un-Republican. Chris was the one talking about the original party of Jefferson and Madison was called the Democratic Republican Party. The current system is anti-democratic and un-Republican. And because it focuses on the maximization of the power of the elite over the individual and over ordinary people. And that's what we got to get away from. Got to break it. I don't want to monopolize the talk, but if nobody else is going to say anything, I can continue. Melissa, what do you think of all this ranting that I'm doing?
It's well deserved. I think we all get there at some point to where we're just, you fight so hard, so much that it's, there's no good words to put into it to say what it is you got to do to fight to move forward. And you're not fighting one person, you're not fighting one state, one bar. You're fighting the whole foundation of what they have built the legal system on.
Well, which is
because you read the Constitution, and the Constitution, was wrote with a different aspect and a different look as to what they thought law would be in this country. They didn't write the Constitution based on administrative law with a bar association.
Well, but the administrative laws that is 90% of what's going on. 90%. And, everything else may make the news, but what controls people's lives. I was in an Uber this afternoon with a lady whose Social Security widow's benefit had just been denied, and it's just so sad that they create all these programs and then, in an arbitrary and capricious way, they deny the benefit of those programs. It is just it is as sad as anything can be. Mm-hmm. Because basically the government creates a hope, and then it creates all these obstacles to the realization of that hope.
So, what's your biggest fight that you want to take on? What's the biggest thing that you want to take out for the CPS cause here?
Well, again, I mean, my fight has never been exclusively CBS. It is about, more than anything, it's about the family court system as a whole, and the fact that the family court system as a whole uses the concept of child protection and best interest of the child as grounds for subverting the Constitution and individual freedom. It is this arbitrary and capricious interpretation of the law that we are going to reduce the whole concept of law and liberty to the point that anything that a judge says that constitutes child protection or the best interests of a child, anything that a judge says, even if it's insane, will be upheld if he says that it's in the best interest of the child, that constitutes child protection. That these are buzzwords that permit mayhem and murder, and the complete abolition of liberty.
Well, thank God I have a dumb judge.
Phew, and an alibi.
What?
And an alibi.
Right, I don't quite follow, but anyhow, the point.
Yeah, no, my judge has always put out these asinine orders that don't say anything about the best interest of the child. He just says he's pissed off and he's going to get even.
That's not
He
right
actually said in his order from the last hearing, the one that got de novoed, he said that the way that my husband sat there quietly in court was proof to the ill wishes and bad demeanor and the lies and the deceit.
All right. That's a little bit confusing, but
well, because my husband sat there quietly, speak when spoken to, mind your P's and Q's, dress, properly to respect the bench, that was proof that he was there to deceive the court.
How did anyone request findings of fact and conclusions of law regarding how he should have behaved?
We just appealed it, and the judge filed de novo on himself.
Okay. But in essence, that does. Now, hang on. If it's de novo for himself, but he's granting the power to another court. You're saying?
Yeah, we're in front of the circuit judge now.
Because basically, de novo usually would mean that he would be hearing the case again himself.
Well, so the way the rule that they filed it under, instead of turning the whole case over to the circuit judge, they only turn the one hearing over to the circuit judge, and then the case returns back to the original judge.
Okay.
Which is absolutely asinine, because he's going to undo anything the other judge does. That's why I have to be very meaningful and very well planned moving forward, because I get the one shot in the dark. Otherwise, I too have to throw my Hail Marys in and hope that one of them sticks somewhere.
Right. I'm sure one will, Melissa. I'm sure.
I'm glad you got faith in something down here, because I'm sitting here thinking I'm going to be buying wedding dresses for my kids by the time I get to court.
As long as they let you do that. That's
that's what I was going to say.
Well, I mean, literally, it's been 2 years, and we've not had any hearings.
That is just arbitrary and capricious. That's the phrase there. It is an arbitrary, capricious administration of justice. And again, that is a characteristic of administrative courts and administrative laws that are not run by the people. You know, if you had a group of citizens who were running that court, they would want to get to the bottom of the problem and resolve it and decide it and go home.
Well, under state statute, a review hearing must be done every 3 to 6 months. Under federal statutes, the Safe Families Act, a permanency planning hearing must be done every year. An adjudication must be done within 6 months of the 72-hour order.
Melissa,
Okay? Yeah.
Melissa, do any of these statutes have a remedy, an automatic remedy for the violation?
Yes,
of those?
they all do.
What is-
I've sent you some of them. The violation of the shelter order, failing to adjudicate within 6 months of the initial removal. The remedy of the everything that I found is that the children must return to the parent, even if it is contrary to best interest. Same thing.
Okay, but does it say who can do that? Does it say that you can do that, or does it say that somebody must do that?
It just says must, that it must be
So in
done.
other words, no one is empowered to effect a remedy. Brenda cannot go do it. I cannot go do it. You cannot go do it. But it ought to happen. Wow, that's really kind of like best interest.
Well, there was a habeas corpus done at the appellate court in Alabama under that same argument because they were 3 months past the required time on a permanency hearing. And the permanency hearing, the remedies that have been given on those is the child must be returned and the case must be dismissed. Under the habeas corpus, the children were returned, and the case was dismissed.
Okay, good.
So, I mean, I'm finding tons of cases with remedy, all in the favor of the parent. And of course, the parents were guilty of a lot bigger things than trying to get their daughter counseling. And they all got their kids back, and I'm sitting here twiddling my thumb, paying all the court pretenders, saying, hey, here's all these remedies. What the hell do we do with them? And they ignore it like it don't exist.
Well, and basically the problem is that when there's no option for self-execution, then you're left at the arbitrary and capricious whim of the administrative courts. And sometimes maybe they will get it right, and they'll publish what they do that's right, so that they can brag about it and say, see here, it is possible to have just remedies. They do this in California mortgage foreclosure. They let a couple of people get their houses back just to prove that it's possible to undo illegal conduct on the part of foreclosures, the foreclosing authorities. But in the meantime, millions of people lose their houses illegally. And so that's why the legal system needs to be returned to the people rather than taking all the power away from the people. Because if people have the power to protect themselves and their own interests and their own families, that just will obliterate all this business of interference by court. And that is the biggest problem we've got, is that we have surrendered our power and our decision-making ability to faceless, soulless administrative courts and other authorities.
Mhm.
Brenda, what do you think?
I was just wondering, Melissa, do you have your rights terminated yet, or?
No, my kids have never been deemed dependent. Literally, they've removed them and they've held them hostage.
Yeah.
And I
And
can't
that's
even
what,
say that they've legally held them hostage because currently they are illegally holding them hostage. The problem
yeah,
is there's no remedy
right.
because it takes barking up the chain of the higher courts
Right.
and
And
honestly, if you don't kiss their ass right in the higher courts, it falls on deaf ears. It's just like I made an email to the DOJ about the mistreatment of the judge. They had the FBI out of Mobile investigate it because a worker called me from there, an officer called me, and me and the agent spoke for about 2 hours. I had to send him over
oh,
documents, including my recorded transcripts. Next thing I know, about 2 months later, I receive a letter that is from one of the highest up of the Alabama Attorney General forwarding a letter to the head of the court system asking them to do something about Judge Hyde's corruption. Guess what happened to Judge Hyde? Not a damn thing. Hell, he probably got a promotion.
no, I was gonna say he probably retired because they'll do whatever they do, these horrible things, and then they'll just retire and just float right out of there.
No, he's a new judge. He's only been on bench 3 years now. He was appointed by Governor Ivey.
That well, the judge that we had on our case was a newly elected judge.
Yeah, no, he ain't
And our
elected.
judge-
He can't be impeached.
What do
Oh,
you mean?
and
An appointed judge cannot be impeached? Is that what you're saying in Alabama?
no, not in Alabama. And the oath of office that a appointed judge takes is different than the oath of office that the elected judge takes.
All right, that's interesting. I mean, Alabama sounds like it's got some interesting laws. Is all I can say.
Screwy laws.
Well,
Yeah,
I mean,
no, actually,
you're saying you're saying that you've got some good decisions there. So that's encouraging.
a friend of mine told me, says if I break down and sue the judge, since he was directly appointed by Governor Ivey 3 years ago, that I should throw her in on the suit too.
I don't. What would the theory there be?
If you don't get around judicial immunity, maybe you could get around the governor's immunity since it's easier.
Not much. It's called qualified immunity. It's basically the immunity that a governor has is basically the same immunity that the police have and prosecutors, and that's a pretty high level. It's not defined as absolute, but it's the step underneath absolute.
Well, it looks like we're rounding the end of the show.
We sure are.
Officially, how long is this show supposed to be?
Well, I do 1 hour from the point of the entourage, the assembly in the front, which is about 5 minutes and 30 seconds. So I give us till 1 hour, which makes it 1:05 is about when we should be getting off. But we call it, like the last 2 minutes or whatever. Say we should start getting. I mean, a couple of minutes over is fine. There's nothing that states that we have to do this at this time. We just keep it, just do it to keep the continuity, I guess you would say.
And that's what it you know, you guys don't mind because there's several different people that I've been messaging back and forth on Facebook, and they're very active in their cases and fighting for their children. And you know, I've already sent them, you know, the your link or whatever, but a lot of people are starting now to want to come out and talk about it when like I myself at first, when it happened to me, not knowing, you know, the magnitude of everything, it's not something that you would openly want to talk about because it's like people feel embarrassed. Your kids are gone. You must have did something horrible. And then we come find out, you know, after my kids were taken in 2016, it took me to be incarcerated for um, over 2 years and to get out and realize that you know, the impact that these family courts have had on so many different people. And it just blows my mind, really.
So, Herbert, any last questions?
No, I think Charles did a very good job with his dissertation, and he answered Darren's question very accurately, and I was very happy to listen and hear about it. Charles, I know you're going in for a big fight of your own. I hope it works out. And
It's the only thing that makes life worth living. Ultimately,
yeah,
is these fights. I mean, again, I keep repeating certain things, and Jerry O'Neill has been this incredible inspiration to me all these years, and he's the one who introduced me to the Parker Doctrine, and basically I have developed that theory, and I just sent you, as I've sent everybody else on here, and I could send anybody else who wanted it, my statement in support, my January 19th statement in support of his candidacy for the Supreme Court. He's going to be on the ballot, and I think that could be the beginning, the crack that would begin to tear apart the and that would begin to tear apart uh, the fabric of the state bar monopoly. And I think we have to do everything we can to tear apart the state bar monopoly. There was no state bar anywhere for the first 150 years of this country's existence. I was looking today at the history of the State Bar of California. It came into existence 1927, and it was copied after an institution in Quebec in Canada. And so there's no American tradition. The first 150 years, it was basically 14 years after the enactment of the Federal Reserve Act that we get the first state bars. 10 years after the enactment of the 16th Amendment on the income tax, and also 9 years after the abolition of state sovereignty in the 17th Amendment. These are the moments, and so that shows that the state bar really was part of the step-by-step centralization and standardization of law in the United States to abolish all traces of the original Republican system. And by the way, you asked about at Harvard, and I sent you an email. I don't know; that'll probably disappear when the show shuts down. I can say
I was there at Harvard during those years.
Really? Okay.
Yeah.
Oh, you guys are tweet.
It's a fun place to be, but you know, it's also very establishmentary, and I was just lucky to be able to hang out with some of the more free thinkers there.
Right.
Okay. Thank you for explaining that, Charles.
Hey, I enjoy talking to you all, and I hope that I can continue to do some good before before my version of Custer's Last Stand. Maybe it'll end up being the Battle of Yorktown instead.
Yeah, stay tuned for that. Right, stay tuned for that.
Well, one of my ancestors, Benjamin Lincoln, was standing right beside George Washington when he accepted General Cornwallis's sword at Yorktown. So I've got high hopes.
Yeah, as you should. All right. Did we all go through? I had lost and we had frozen. Did we get everybody get their last comments then?
Yeah, I just want to say last night, after Charles had mentioned some kind of glitch happened, he said something about the CIA, and then my electricity blinked off. I couldn't get the show. That was amazing. I'm like, I know one time we were trying to get on our internet, and sometimes you have to redo the thing, and it'll show up like all the different accesses to the internet. One of them said FBI ban. It's, I took a picture of it with the other phone. I thought that was hilarious.
You're breaking up very badly, Brenda. Hardly understand you.
Oh, well, there you go. There's my last word. AI judges is the only way to go. AI judges.
Yes, sir. Yes, ma'am. All right, guys. Thank you all for joining me tonight. We'll catch you guys all tomorrow night. Same bad time.
Night, everybody.
Same bad.
Thank you. Bye-bye, Charles.
Good night, guys.
Bye-bye,
Good
Melissa.
night, guys. I'm
Night,
trying to
guys.
get everybody off here. Should I do my thing here? Well, I can't get anybody out of here. So, well, folks, there you have it. That's another night of CPS victims hunting justice. As you can see, these lawyers that truly do fight for us are, they got a long road ahead and they have a rocky road to fight. So when you find them, make sure you hold on to them. Make sure you let them know that they're ass-kicking attorneys and that they're doing the fight for the right thing. So I'm the CPS Punisher. I'm getting out of here, guys. Have a good night.